Explain to people what is estate planning.
Okay, estate planning is looking into your world and knowing that you have assets, whatever those are, or bounty, as the legal term is. A will is about what is a person signing a last will and testament, knowing that it declares what they want to do with their bounty. Now that word's not in the will, but that's the legal jargon, as I remember. It's not mutiny on the bounty; it's bounty, like whatever. So if I looked around my office, it's all stuff in my office. That's tangible personal property. That's a different way. But an estate plan will allow you to lay out what you want done with all the money you might have, whatever that looks like. If it's coins I save nickels, dimes, pennies, and quarters. Who knows why, but I do. I don't know that I have thousands of dollars, but I have hundreds of dollars, and I hate to wrap them up because then I have to start filling the bottle again. So anyway, but that's part of your bounty. Well, you might say, you might have a piggy bank that you've had since a child. My husband had one that unfortunately got stolen. But you might have a piggy bank you've had since a child, and you want that to go to a specific person. It's full. You have no idea how much is in it, but you want that piggy bank with whatever's in it to go to a certain person. Well, you would want to write that down. Or you have CDs that matured and you never cash them in, but you want to be sure you've designated who they go to. That's beneficiary designation. So that's part of an estate plan, because if you write down you want them to go to Sophia, let's say, and you haven't put her on that piece of paper and you're not married, she doesn't have a legal right to that money.
Whoa.
Your family has a legal right to that money. Your blood family, whether it's children or parents or nieces and nephews. So Sophia, whom you've been with for a long time, as much as you may think, of course it's hers, because we've been together all these years. That's good thinking, logic. But if you go to a court of law, unless you've written it down somewhere, even in your will, that says Sophia gets all my money markets or CDs, she doesn't have a leg to stand on if people in your blood family say, sorry, we never liked you. We don't care how much Steve has. We're going to argue. We're going to fight you for it. So estate planning is putting that all together. You said at the very beginning, it's the most important part of law, whatever. Just what I do is what estate planners do. It's helping people pull together what they have in one place in their mind and putting it down on paper. So people are going to take care of them in this life or take care of what they have after they're gone. Do what you say you want. And there's great peace of mind there's extraordinary peace of mind in getting it done. And I know personally, I keep coming up with things. I'm going to have my colleague and mentor review my estate plan because I did it years ago and I did it with somebody I didn't know. We just decided to do it. It was finally time. And I'm thinking, holy mackerel, Debbie, you need to be sure that you've got everything in place. So that's what estate planning is. It doesn't matter how much money you have. It doesn't matter.
Debbie, who needs to have an estate plan?
Well, people really struggle at hearing this. At 1 second after midnight on an 18th birthday, whoever that 18-year-old is needs an estate plan. And people say, that's crazy. They're only 18 or they don't have anything. Right? I get it. I learned about that years ago when I was a sort of semi-active associate with one of the prepaid legal programs, when somebody told the story of an 18-year-old who had a catastrophic injury in a car accident, didn't have a will. Why would an 18-year-old have a will? He was raised by his mom. His father had nothing absolutely to do with him. And because he didn't have a will, when the wrongful death or personal injury thing settled, his father got 50% of that money because there was no will. So that's the tragic piece of it. Camp Lejeune cases, the people who are families or victims of the Camp Lejeune, they need to do, if there's no will, or they need to do a probate so they can be in line for their family descendants, the spouse and family of the people who died as a result of that, to collect a class action settlement. But the biggest thing that 18-year-olds struggle with that, which is understandable. And parents don't understand that they cannot call a doctor anymore once that child turns 18. They can't call a teacher anymore once that child is 18. They can't access bank accounts if that child has one in their own name once that child is 18. They have no legal rights other than they don't even have a legal demand to support them anymore, but they have no legal rights to help them without the child saying so. And then any asset. I mean, you mentioned recently, Steve, that you did your first plan when you were 27 or 28 because your brother was an attorney and said, you will do this. And you said, okay. But I don't remember you saying you had a lot of assets that you owned a fancy car or owned a home or anything. You may have, but you weren't married. And as I remember, you didn't have a family. So why would you do it? Except that he was smart enough to say, you're 27 years old. And if God forbid something happens to you, you need to put me in charge. You need to let somebody know what you want. So once you're 18, you need one, whoever it is. 18 is the legal age of adulthood, I think, in every state. It may not be the drinking age, but it's the legal age of adulthood. And that's a determining factor. So that's who needs it, everybody over 18.
I'll bet you've seen some hellacious cases of people who didn't plan.
Oh, horrible cases. Tragic mostly for the impact. I mean, I think of the first, actually, I don't know if it was the first probate I did, but it was one where this woman died and she had quite a bit of money. Let's say she had $1 million. I don't know if it was quite that much. But somehow or other, she had beneficiary designated half of it. And she hadn't beneficiary designated the other half. So it cost her family, I think, about $9,000 to get it done, and it could have cost them nothing if she had just called whoever had the other half of the money. And so that was tragic. It was tragic. It was complicated. The woman she'd appointed lived in England. She couldn't do it easily because she didn't live in a city, and documents needed notarizing. And then we had to get waivers from everybody to appoint a nephew, and it was crazy. I mean, it was crazy. And other things are just, right now, I've got one where a woman died. Before she died, her power of attorney signed the title of the car over to a stepson. And the woman died in Florida. It's the only place I can practice. And he lives in New Jersey, and the Motor Vehicle Bureau up in New Jersey is giving him a hard time about transferring the title. Now, if they'd done it while she was living, probably he wouldn't have had any trouble. But now they're doing it with a power of attorney and a death certificate, and so he's got to demonstrate that it was really done legitimately, and nothing of great value, but it's the emotional impact of not planning. People continue to think, like you and Sophia leave your house to a favored niece or nephew, and you think, oh, it's my will. Well, that's great. And you have to go to court to get it. It's great. I mean, it's good that you did that, but it's not great in terms of what your loved one is going to have to do to get it. So, and those are horrific because they could have easily been avoided.
Oh, absolutely.
They could have been avoided. Well, hence my stories at the beginning about, have you thought about this? Have you thought about this? And people go, no, I never thought about that. I thought it was straightforward. No.
How does somebody choose who to represent them?
It could be really hard. The thing I've seen recently where like somebody's older and they've appointed their spouse, and then they realize, oh my gosh, my spouse is this, and I mean older, 70s, 80s, whatever. I'm not talking about the 30-year-old thinking somebody 40 years old, 70s, 80s. And they think, oh my gosh, that person couldn't handle that emotional roller coaster, making healthcare decisions, whatever. You have to really, well, for the healthcare surrogate and the power of attorney, huge amounts of trust. In Florida, powers of attorney go into effect as soon as you sign them. And every one of them includes the ability to make banking transactions, deposits, withdrawals, like write checks. Minimally. Well, your power, and I've seen it, I haven't experienced it personally, I've heard, you give somebody power of attorney, they could literally clean you out. They could sell your home, or they have a power of attorney. It's one of the standard, it's a standard power in a power of attorney. And in Florida, you really cannot do limited powers of attorney. So a limited power of attorney is where you and Sophia have moved out of state, you're selling your home in Florida, and you hire me, you appoint me, limited power of attorney for the express purpose of selling your home at 123 Main Street. That's as far as it goes. Because you're not going to, this is before DocuSign and all that. You're not coming back to Florida to sign sales agreements. So you appoint somebody to do it for you. I did that once because my client lived in New Jersey and has no computer technology. She barely has a phone. So healthcare surrogate, you really have to appoint you've got to appoint somebody who's going to do what you want at the end of your life, whatever that is, not what they want. Not what they would do, but what you would do. And you have to be careful because some people won't. They'll keep you alive when you don't want to be, or they'll let you go when you don't want to be. So hard. And that's a great conversation for an attorney to have as a counselor. Like, you got to really trust. But I think you got to really trust. I hear what you're saying, and I get that it's hard, and you got to really trust. You just got to really trust. So yeah, those are some of the hard choices. Who do you leave a home? Who do you leave the home to? Who do you leave the car to? No easy choices, necessarily.
If for people who are not watching right now, who are listening on radio, my dear friend has had her cat, our co-star of our show. What do people do who have pets when it comes to estate planning? Like, where is the pet going to go?
Well, very, very many of them. Actually, I have no idea where he's going to go. Actually, I have it.
But what do you tell your clients who have a pet?
Well, I think in some aspects, maybe it's good. I'm the shoemaker who has holes in their shoes because they're too busy fixing other people's. Florida does allow pet trusts. So you can actually set aside money in a trust for somebody to take care of your animal. Most people their families already agree that if there are any animals living when that person dies, they will take care of it. Other people don't know. I mean, I got one of my cats from a family where this poor cat, both of his owners had died within the space of 90 days. I mean, it was horrible. And one of the women at church put out a plea, and I had lost a cat I'd had for 18 years and wasn't getting another one. And then a friend called and said, are you ready for a cat? And I went, oh my God. So yes, so I went and got George. George was his predecessor. And it's a real consideration. I had one client who put aside, at the time we did his documents, they had 5 cats. So they put aside a good bit of money for a specific person to take care of the cats. Now, if when the 2 of them die, they have 1 cat, that person gets all that money. If they have 5 cats, they get enough. And it's a really important consideration. And I know people who, once an animal dies, they won't get another for that fear. For that fear that if I die before the animal, who's going to take my animal? It's a big question. So I really do appreciate you bringing it up, because I thought about that. Those that they're watching thinking like any other profession, you have it all together. Trust me. I haven't figured this one out.
My Sophia has 2 cats, and both of her sisters love the cats. And I was thinking, what happens if, God forbid, something happens to Sophia? If it's not in the will, which sisters get the cats?
Well, they can fight over it, but you get the cats, actually, because they've lived with you. It's more that what happens after that. Because you love the cat. I mean, didn't you tell me Ralph is one of the cats? Right, Ralph?
Yeah.
Right?
Ralph looks exactly like your cat. Exactly.
And I want you to know, he showed up at 9 minutes because he must have known you were coming. I told Rebel, no, he knows it's the last Monday of the month, so here he is to see Steve. That's I'm glad you asked that question. I'm going to start asking people, so thank you. I really appreciate that.
Well, you know what? This show always goes by so fast. Debbie, give everybody your phone number and your website address.
So my phone number here in Tampa is 813-586-1332. 813-586-1332. And my website is London, like the city, LondonBakerLaw.com. People drop out the law sometimes, but it's LondonBakerLaw.com. Email is debbaker@LondonBakerLaw. Guys, I told people, if you don't live in Florida, I can't do paperwork for you. But if you're listening outside Florida, you know people, and they just have a question, I'm driven to be of service, and I'll answer any question with the caveat that if you live in Georgia, you got to find a Georgia lawyer. But it's general questions about how to ask. And I love to help, and I love doing this show. This show is so much fun.